Nobody questions the right of a Syrian refugee to return to their homes. On the contrary, we saw in the Western media how the Europeans, as soon as Bashar al-Assad's regime fell, they were like, okay, well, Syrian refugees, pack your bags and leave. This is not disputed anywhere except for the Palestinians. That is the only scenario where whenever you talk about a right of return, it's like, well, no, maybe they should get compensated and resettle somewhere else. And that's a case of Palestinian exceptionalism. Every refugee is encouraged to return. Every refugee has the right to return. Palestinians have a right to return. They want to return, but they're precluded from returning. The international community is always fixated on what Jordan or Lebanon or Egypt or Syria should do, but not on what Israel has the obligation to do. That's the only state that has an obligation under international law in terms of a durable solution for refugees.
Welcome to another episode of This Is Not a Watermelon. My name is Mikey Mhenna. Today on this series, we have Lena El-Malak, who is the author of Stolen Nation, The Right to Reparation of Palestinian Refugees. Lena, welcome to the series.
Thank you. Thanks for having me, Mikey.
When people hear reparations, a lot of people, especially those who have some connection to the U.S., think about sort of 40 acres and a mule. This idea of African-American slaves who are asking for reparations. Big picture, where have reparations actually been given? When in the last 100 years, 200 years, 300 years, have a people asked for reparations and actually been given?
That's a very good question. And it also depends reparations for what. Like my book focuses on reparations for property, but not reparations for the full harm of the Nakba. And so there are more precedents for tangible forms of reparations, like restitution of property and compensation. Would have that, for example, in Bosnia, you had a relatively successful claims commission, depending on who you ask, of course. But at least there was political will to set up a mass claims commission and address the issue of property claims. Holocaust reparations were, successful to some degree as well. Other cases that are where it's, you want reparations for slavery, so it's not something that you can quantify, and very often it's like the descendants, the second, third, fourth, fifth generation claiming compensation for something that their ancestors had gone through and obviously had ripple effect on their lives over the course of multiple generations. But it's just harder to, find a cause of action, to find the right forum for to adjudicate these types of claims. So it's a bit trickier for these types of claims, and that's in large part why I chose to focus my own research on property claims. I wanted to tackle something that was very specific and tangible, and give kind of like a blueprint of what are our rights, what happens, what are our rights, and how can we claim them?
So when we think about the Nakba, right? So this is 100 years of, more than 100 years at this point, this is predating the Nakba, obviously, but 100 years of this war in Palestine where land has been taken and stolen and people's rights have been violated. At what point did Palestinians in Palestine start to think we need to go to a third party to protect ourselves from the acquisition, this sort of theft of land?
I'm not sure actually which and which third party would that have been. That wasn't really part of my research. I looked at the mechanism that was used to expropriate property, and I don't think that the ultimate outcome of land expropriation was evident very early on. I think there was probably during the British Mandate, it became evident that there's something being cooked behind the scenes, or actually even quite openly, because there were. British were facilitating the immigration of Jewish refugees. They were also part of their the so-called land settlement ordinance, so that the land settlement mechanism that they implemented manipulated the vagueness of the Ottoman land code, and that's essentially what facilitated the expropriation of property. It was just that, clash of two paradigms of, property ownership. The one that existed during the Ottoman period, which is rarely, or just for some categories of land, which is mulk land, and waqf, it's akin to private property ownership. But the majority of land in Palestine was owned under a different category of ownership called miri, which is that it was owned by the owners by the individuals as long as they were cultivating it. And so it was a little bit different. And there were other categories as well. So and the emphasis there was on use and communal ownership rather than the very narrow individualistic type of property ownership, which you find with the, in the Western models of land ownership. And so I think, the Palestinians probably realized at the beginning of the British Mandate that there was something that was being prepared and that there was like an intention, especially because the British Mandate embedded the Balfour Declaration, which was a political declaration until then. And then it gave it also that's kind of a legal status by being incorporated into the British Mandate for Palestine. And so I think that's when probably they started realizing that there was something really, harmful being schemed against them.
Yeah.
And that's when they started revolting against it. I don't know if they went to third parties, but they certainly.
Well, the British could be a third party.
Yeah, okay. I'm not sure actually if they went and pleaded with the Brits as much as they just revolted against what was clearly being devised against them. But yeah, I think, the property claims were it became apparent where we were heading during the British Mandate, and obviously with Israeli laws that were implemented as soon as the State of Israel was created, made it abundantly clear that the aim was to sever the legal ties between the Palestinians and their lands.
So in the opening chapter of the book, you talk about these like three distinct periods: the Ottoman period, the British Mandate period, and Israeli legislation sort of post 1948. Can you just give a high level overview of how land was held, how land was owned during these three different periods? If and were deeds basically just rewritten?
Sure. No, these weren't rewritten. It was just, as I'm saying, like just a different type of land ownership. So or legal system during the Ottoman period, the categories of land, there was waqf, mulk, miri, miwat, and metruke land. And in short,
Can you explain what those are?
Sure. So waqf is religious land owned for religious pious reasons, or set apart for these reasons. It's still a form of ownership in most Arab countries that were under the Ottoman Empire at one point. Mulk is, just as the word implies in Arabic, it's like full ownership, and this is the most similar type of land ownership to, private ownership in Western legal systems. And then miri comes from emir. It means that the land is like there is a vested interest in the emir or in the sovereign. The sovereign has a vested interest in the land, but as long as it's being cultivated, it is, you could argue, like privately owned actually by those who are cultivating it. And even over time, so initially there were restrictions on the ownership in the sense that it could not be bequeathed, to the heirs, and that they had to pay a tax to the sovereign, and it could not be sold. These were like the three main restrictions on that form of land ownership. But even over time, actually, the Ottoman land ownership regime was a lot more relaxed, and there aren't any cases of land, as we use a term in legal, is cheating back to the sovereign, so reverting back to the sovereign. There were no precedents of that happening because the land was constantly cultivated, and then the heirs cultivated it, and the restrictions on inheritance were removed over time. So you could argue that miri, which was the predominant form of land ownership in Palestine, was akin to private land ownership.
By predominant, you mean like 60%, 70%?
I can't remember the exact figures, but it was the majority of of the land in Palestine was under was Miri land. It wasn't Mulk was a very small proportion. I'd say probably less than 10%. Miri, I would argue, yes, probably would be around that much, around like the 60% mark. And then you had Mewat and Metruke, and Metruke would be the land that is Metruke, like a road or something. And Mewat was also a form of land that is communally owned, so the land of the villages, basically. What happened afterwards, when the British Mandate begun, is that they, instead of reforming this form of land ownership and clarifying the status of the land, etc., they just kind of like built on it and initiated a land settlement process, which was, again, there was this clash of paradigm between the Western, very strict methodology of defining ownership, which rested on registration also, which is not something that was very common during the Ottoman and Ottoman period. In fact, actually also registration at the time of the Ottomans was a registration of title. It was a record of transactions as opposed to a record of the actual like plot of land. There were very few, cadastral surveys and maps clearly delineating the land. And that's because, again, if you think of like the indigenous form of ownership, the land is delineated by saying, well, it's the land between this river and then this mountain, and then there's this little well, and so on. While the British mandates, the British land ownership system is different, and it's very much based on a registration of deeds and title deeds and property and maps. And so there was a lot of vagueness, and that vagueness was manipulated by the British, and they focused on, they tried to do what they call the land settlement process, which is to try and define and grant like clear title to certain plots of land within Palestine. But coincidentally, they focused that land registration system, the land registration process, in the areas that eventually were allocated for the Israeli state, the Jewish state in the partition plan. So that is what they had done. And then the point that I want to make is actually, despite the fact that they facilitated the immigration of the Jewish population, and they also worked on the registration process with seemingly the intention of giving clear title to the Jewish population, notwithstanding all of these measures that the British introduced. At the end of the mandate, Jewish ownership of land stood at less than 7%. In fact, the majority of the land ownership was with the Palestinians, who constituted also the majority of the population of Palestine, 70% of the population of Palestine at the time of partition. It just exposed kind of the unfairness of the partition plan and the reason why it was ultimately rejected by the Palestinians. And in terms of what the Israelis introduced afterwards, it was the Absentee Property Act, which then became a regulation. And the Absentee Property Act was based on a principle in international law of, enemy property laws, which were used in the Second World War and other scenarios. Sorry.
Hold on. I want to stop you for a second, just because I have so many questions.
Okay. Sorry if it was like a deluge of info.
No, it was a deluge of info for sure. So for example, the Absentee Property Act, right? Like, take us. You're living in this material, right? So like, take us back to that actual moment. Who's actually enforcing this act? Who's writing this act? Who are the actual people who are enacting these regulations? Who's enforcing it? What is the security apparatus that's actually enforcing this?
I mean, the government of Israel, which was established by then, which had just like newly formed, basically, state of Israel, adopted this act initially, and then it became a regulation. And the act was modeled on enemy property law principles that were used in the Second World War, and they're not odds per se, in the sense that it is a mechanism that was used to kind of freeze, let's say, the assets of your enemy during wartime. That was the objective. It's just so that your enemy would not have access to assets that they can use to pursue the war and finance their war. And so if that property was based in enemy territory, they would usually hold it under custodianship until the war ceased, and then they would release them. Now, what happened in the case of the Palestinians is that the Israelis used that mechanism, that legal strategy, let's say, of enemy property law, and identified the property of individuals who left between a certain period of time, and they did a census to determine those who had fled. And the requirement wasn't that they would have fled and crossed a border, because when they ran the census, unfortunately, individuals were also displaced just from their villages at just a few miles away. Were also fell under this very abstract definition of an absentee. And so, for those internally displaced Palestinians, they were absentees for the purposes of the law, but very much present still within the territory of what became the state of Israel. So they were just like not in the village when they undertook the census. And so they're called. It's this fictional category called present absentees, which continues to exist to this day. But in terms of the refugees, when they did the census, they basically figured out who was no longer in Palestine at the time, and it didn't matter why they weren't in Palestine. They could have been studying abroad and got stuck and couldn't return because of during the Nakba. But also, what is missing from this description is that the Israel also adopted laws barring Palestinians from returning. So they did the census, and then they barred Palestinians from returning, and they said, "Well, now you're an absentee." And then they proceeded to expropriate the property. And initially, they just held it under the custodianship of the absentee property custodian. And they were granting long leases for that property. Now, this didn't please one of the main organizations that were responsible for the settlement of the Jewish settlement of land in Palestine, which was the JNF. And the Jewish National Fund started settling land in Palestine from 1901. And so they influenced the adoption of the absentee property regulation, which allowed for the sale or the disposal of the property to a so-called development authority and to the JNF. And so this marked the beginning of the severing of the legal tie between the Palestinian owners and their land, because the land was no longer held under custodianship until a resolution was negotiated. No, it was the land was severed. The legal tie of ownership was severed between the original owners and the land. And subsequently, there was another law called the Israel Land Laws, which identified or defined Israel lands as land owned by the state or the Development Authority or the JNF. And so that was how land was predominantly owned in Israel. Basically, it was just land that was owned by these three main entities. And then in 2009, there was another land law that allowed for private ownership of land. And so again, the whole aim is to sever the ties, to make it incredibly difficult, if not impossible, for Palestinians to be able to claim their land back, to have a restitution of their land because of all of the obstacles that they've put in place.
Yeah. Okay. There's a section of your book that talks about UN Resolution 194. Can you explain the significance of that resolution in particular and the enforcement of it?
Sure. So Resolution 194 was adopted in December of 1948, and it's the most commonly cited resolution on the rights of Palestinian refugees. And it was the basis for it was the report of the UN Special Mediator the UN. I was going to say UN Special Rapporteur is the mediator, the UN Special Envoy, basically for Palestine, or the UN mediator, Falk Bernadotte, who had written a report that essentially called for, the repatriation of the refugees. He called out the fact that they were, expelled from their homes, the reported on their forcible expulsion, demanded that they be allowed to return to their homes, and to have compensation for the damages that they incurred. And he was assassinated actually by an Israeli group called the Lehi Group, paramilitary Israeli group at the time. But his recommendations informed the drafting of Resolution 194. And
where was he from? Can you say his name again? And where was he from?
He's Swedish. He's a Kont Folk, Folke, Bernadotte, Bernadotte. And actually, if you go to Stockholm, in the park in the main city has a statue of Folk Bernadotte that I just stumbled on when I was visiting once, and
Wow.
it's quite refreshing to see it there. But yeah, so he's Swedish. And so Resolution 194, the most significant paragraph in it for the purpose of the refugee issue is paragraph 11, which called for the return of refugees to their homes. These were the words. I don't have the paragraph in front of me, but these were essentially the words that were used: to their homes, not to the areas from which they were displaced. Even though there was a recommendation during the drafting stage by Guatemala to refer to the areas from which they were displaced. And that recommendation was rejected, which indicates the intention of the drafters to return the refugees to their homes, like quite literally to their homes, not to, another village nearby.
Yeah.
Or
something. I'll read it word by word.
Yes, please.
Resolves that the refugees wishing to return to their homes and live at peace with their neighbors should be permitted to do so at the earliest practicable date, and that compensation be paid for the property of those choosing not to return, and for the loss of or damage to property which, under principles of international law or inequity, should be made good by the governments or authorities responsible. So, Lena, I have a question about this. Mm-hmm. If I'm looking at anyone who's listening to this now who says, okay, let me look this up, they go to Wikipedia, they see in favor of this, there's many countries, including Argentina, Australia, Belgium, Brazil, all these different places. Against are so many Arab countries, including Egypt, Iraq, Lebanon, Saudi Arabia, Syria, Yemen. But it seems like that clause in particular is a clause that is advocating for the right of return. Like, help me understand the context in which so many countries that are advocating for Palestinian rights would vote against this.
I mean, I don't remember exactly, actually, why their position was against that, and I think that's sometimes we also have to look at all of the rest of Resolution 194.
Yeah, of course.
I mean, I'm focusing at resolution at paragraph 11. Because I remember even like more recently, there was the very first, for example, resolution calling for a ceasefire in the General Assembly was, I think, Tunisia abstained or voted against. And I was like, how could they? But then actually when you read, it's there is a reason why they would have abstained. It's because, they were against one of the words in there. And so they didn't want to look like they were endorsing a resolution that was problematic in part, and so they could have stated their dissenting subsequently through a press release, etc., clarified why they had dissented. Perhaps I don't know what the position of I'm trying to remember what could have led to them not approving this resolution. It could have been because it called also for the establishment of UNCCP, the UN Conciliation Commission for Palestine, to resolve the dispute, which maybe they felt like, the resolution should have been clear. We should just reverse the historical injustice of partition. Perhaps that is why they had voted against it. There was also a paragraph in the resolution that calls for the establishment of there was a refugee agency, but then they called for the proper establishment of UNRWA, which was established a year later in 1949. And the main aim of UNRWA, as its name indicates, is to provide also rehabilitation of refugees in their host countries. And perhaps they were against that. I would imagine that's probably what they were. They were against rather than the return and rather than paragraph 11.
Yeah. The phrase right of return, me as somebody who grew up in Lebanon, I've only heard it within the context of Palestine. Is it a a sort of a generic generic concept in international law that is applied in every other situation, but just not applied in Palestine?
Exactly. It's precisely that, actually. So under international refugee law, there are three durable solutions that the main agency mandated to provide solutions for refugees, or to provide what we call legal protection to refugees. The United Nations High Commissioner for Refugees typically tries to implement. So when a person flees from a war zone, they are asylum seekers. Once they prove that they are, refugees fleeing persecution, they are granted refugee status. And then the UNHCR proceeds to find one of three durable solutions, which are voluntary repatriation, local integration, and resettlement. Only one of these three, which is voluntary repatriation, is a solution that a refugee has as a right. So every refugee has a right to voluntarily repatriate to their homes. And that is the preferred solution for the UNHCR, is once it is safe for refugees to return, to facilitate that voluntary repatriation to their homes. Local integration and resettlement are subject to the discretion of the host country and the resettlement country. Some countries want to take refugees, others, as we can see now, the whole debate in Europe, but also in the States, they just don't want to. They don't want to have any refugees anymore. And local integration is also subject to the host country, just like Lebanon and Jordan and Syria, etc. They're they don't want to. Like Jordan absorbed actually refugees in 48, but it's not Jordan's obligation to absorb any refugees or grant them citizenship or anything of the sort. That is not their obligation. Their obligation under international law is, if somebody's fleeing a war or persecution, their obligation, everyone's obligation, is an obligation, what we call an obligation of non-refoulement, which means that you shouldn't push them back. You shouldn't push them into a place where they would be at risk of death, essentially. But beyond the obligation of non-refoulement, they do not have an obligation to host the refugees. And so if we look at all the other scenarios, nobody questions the right of a Syrian refugee to return to their homes. On the contrary, we saw in the Western media how, the Europeans, as soon as Bashar al-Assad's regime fell, they were like, okay, well, Syrian refugees, pack your bags and leave. Regardless of whether actually it's safe for them to return or not, they created like a serious issue, and it scared a lot of asylum seekers and refugees, and Syrian refugees in Europe who still wanted to see like how things will pan out in Syria before making a move back. And so this is not disputed anywhere except for the Palestinians. That is the only scenario where whenever you talk about a right of return, it's like, well, no, maybe they should get compensated and resettle somewhere else and all of that. And that's a case of Palestinian exceptionalism. Every refugee is encouraged to return. Every refugee has the right to return. Palestinians have a right to return. They want to return, but they're precluded from returning.
Yeah. It's not, and to be clear, it's not precluded from returning by international law.
No, of course not. It's because by the state that should facilitate their return and cause their displacement should be the one that reabsorbs them. And that's the thing. It's like the international community is always fixated on what Jordan or Lebanon or Egypt or Syria should do, but not on what Israel has the obligation to do. None of these countries have an obligation, as I said, besides just hosting the refugees while at the time when they were at risk of death and persecution in their original home. But beyond that, which they've done, but beyond that, they don't have an obligation to resettle them. They don't have an obligation to grant them citizenship. And this is not a point that's debated in Europe, for example. Like a lot of European countries during the Syrian war provided, a residency, temporary residency, what they call temporary protection for refugees, until the situation resolves itself, and so they can go back safely to their homes. And that's kind of like what would happen, and that's the obligation of these host countries. They are not obliged to grant citizenship to anybody. But Israel has the obligation under international law to allow Palestinian refugees to return to their homes. That's it. Yeah. That's the only state that has an obligation under international law in terms of a durable solution for refugees.
So, I mean, right now we're recording this. I should have said this at the very beginning, but we're recording this on February 25th, 2025. I'm curious about you as a scholar and somebody who's written this book and done this this analysis. How do you feel about what's happening now from a legal perspective? Every time I speak to an international lawyer about Palestine, I always feel for them, because it seems as though international law does not apply in this situation. Because the game is rigged. It seems abundantly obvious that the game is rigged.
Look, I think we're all, very disillusioned at one point, but at the same time, I think it's, there's obviously a lot of disappointments, but also at the same time, the expectation that a lot of us held for international law is not really accurate. Basically, there was the disappointment was in large part due to the fact that there was a gap between what we expected international law to do and what it was actually designed to do. And I think once you reconcile these two, you realize that actually international law, and many scholars have argued that, especially after during the genocide and with the ICJ provisional measures, and when it didn't call for a ceasefire, they were like, well, that's what it's designed to do. International law ultimately was created by the colonial powers that were victorious after the Second World War, and it's a tool that is used to regulate others rather than to regulate these powers, and they retain the veto as permanent members of the Security Council, and there's this always this kind of lack of enforcement unless the Security Council approves it. So it was designed in a way to consolidate power in the hands of those colonial powers that were victorious post the Second World War, not to help in the decolonization movements. I don't think that was the aim for which it was designed. On the contrary, it was designed as a tool, I think some argue of colonialism as a tool of, regulating the expropriation of resources by these colonial powers. And so once you think of it this way, you realize that actually, well, it's performing exactly as it's meant to perform. Large, like the superpowers can just veto the resolutions that they don't like and protect their allies and exploit resources and justify an act of aggression when they want to, as they did in Iraq. And, and they can just bypass these, the laws. And as you said, the system is rigged. But also, I think there is a great scholarly work, which not having been an academic for the past 15 years, I'm not heavily involved in, so I can't talk a lot about it. But there are scholars of what we call TWAIL, so third world approach to international law. So there are scholars who are saying, okay, let's not throw the baby with the water out, but let's not this public international law altogether, but let's try and think of a third world approach to international law, and reform basically international law and infuse that third world approach, because it is a very Western centric legal mechanism, basically, or legal order. So that's the first thing I would say, is that the disappointment was in large part also due because of the expectation that we had of what the law is versus what it was actually designed to perform. And now this is not to say that, again, like public international law is useless altogether. On the contrary, it is one of the battlefields of our liberation movement. It is one of the tools that we need to use and deploy. And to be honest, we hadn't, at least as Palestinians, we hadn't really used this strategically until recently. Like the ICJ advisory opinion was, a monumental opinion that we've had that confirmed things that a lot of people, we say it is an occupation, but it wasn't. It actually, we didn't need that kind of affirmation. We didn't need that statement to be made by the highest court of justice on the status of the occupied Palestinian territory, because the Israelis were constantly manipulating the words and saying, no, it's disputed territory. It was never really occupied from the Palestinians because the Palestinian state didn't exist. The territory belonged to Jordan and Egypt. And so why are we even negotiating with the Palestinians? I mean, there were so many things, if you really delved into it, that the Israelis argued. And that to have that legal clarity with the ICJ advisory opinion was just, phenomenal. It's incredibly important that we had that clarity, and we need to build on it. So that's the thing. The law is just a tool, but ultimately what individuals make of it and how we use this ICJ advisory opinion to pressure our governments to impose embargoes, to divest, to impose sanctions, etc. That's where the power really lies. It lies in us. It doesn't lie in international law, because there is no enforcement mechanism in international law, or the enforcement mechanism is subject to the will of the Security Council, and therefore, in that sense, you could argue it's right.
Yeah. Speaking of those processes, so many people listening to this, I would imagine, have heard people say, oh, the debacle of Oslo, or, Camp David was a huge failure, and Camp David 2 was a huge failure. Can you try to explain, sort of put meat on the bones for, imagine an 18-year-old listening to this?
Sure.
Put some meat on the bones. What actually happened in those places?
So I haven't looked into Camp David. I was in the agreement between Egypt and Israel, but I can talk about the Oslo peace process and the Madrid peace process and everything that came after it. And I think this marked the beginning of the removal of the Palestinian issue from the international sphere, because up until then, as I mentioned earlier in this podcast, I talked briefly about something called the United Nations Conciliation Commission for Palestine. And so there was a commission that was established to try and find a solution to this problem, not just in terms of the property, but also just to try and resolve this, this issue that was created by the partition of Palestine, which was the international responsibility, essentially. So the international community created this problem. The international community had the onus to fix it. And it tried, but obviously there was no political will. And towards I think in 1965, it's discontinued to provide its efforts, and it still exists, but it doesn't carry any functions. But still, the issue of the Palestinian refugees, the issue of the broader issue of Palestine, the question of Palestine, was still fell under the remit of the UN, and the international community as a whole had responsibility towards the Palestinians because they created that issue and they needed to resolve it. What happened in Madrid is a shift from that internationalism to a bilateralism, to a bilateral approach, which started with Madrid and then it was consolidated with Oslo. And it was a bilateral approach to the negotiation process that also did not make any reference to international law. And so that leverage that Palestinians had, despite all of the critiques that we make of international law, but they had also, some capital in terms of their positions in international law. They had some bargaining, chips there. It was taken out of the negotiation. Any reference to international law was not part of the Oslo peace process, the so-called Oslo peace process. It was a bilateral process. As I said, the mediator is a biased mediator, as actually more of a party rather than a mediator. Every time the Palestinians tried to bring international law or refer to a resolution, etc., they were accused of negotiating in bad faith. As if, the assumption is that if you demand your rights, you're just acting in bad faith. We're trying to find a so-called, pragmatic solution, which is essentially a solution that was going to be imposed by the oppressor on the oppressed. So it was political pragmatism became the code name for how to handle the negotiations. And then they fragmented also the issues. There were 5 so-called permanent status negotiations or permanent status issues, which were, the refugees, Jerusalem, the borders, the settlements, and water. And so they fragmented the issues. They also pitted one issue against the other, which was the refugee issue, which was relegated to the final status, so-called final status negotiations. There was this incremental approach, and so there were some issues that were relegated to final status negotiation, the refugee issue being one of them. And the refugee issue was essentially pitted against the right to self-determination of the Palestinians. It was almost like there was a tacit acceptance, including by the Palestinian negotiators, that the refugee issue will just be resolved through some sort of compensation package for most refugees. And
what year was this?
This was, you could say, the late 90s. Basically, there were many different proposals that were presented. There was, the Geneva Accords, the Taba, the Clinton parameters. There were many proposals throughout the years, which I detail in my book.
This is including Camp David too.
Including Camp David too, yes. So all of these proposals, with the exception of the Taba negotiations, was the first time that there was a serious discussion of the refugee issue and, proposal of allowing some return to some and the establishment of a claims commission. And it was like the most rigorous proposal when it came to the refugee issue in particular. But overall, if I'm still, explaining it to an 18-year-old, I would say the problem is, the move from internationalism to bilateralism, fragmentation of the issues, pitting one issue against the other, relegating the refugee issue to final status negotiations, and almost implicitly accepting that they would have to concede their right and sacrifice it in favor of a right to self-determination, a collective right to self-determination. The also peace process is also incredibly flawed because it ignored a segment of the Palestinians entirely, which were the Palestinian citizens of the state of Israel, and they were completely overlooked by this issue. So marginalization of the refugee issue, completely ignoring the Palestinians. I don't like to call them 48 Palestinians. I call them Palestinians al-Dakhil al-Muhtal. So the Palestinians of Palestine, ancestral Palestine. So these were the groups that were completely ignored and omitted from that framework of Oslo. And so it contributed in many ways to the fragmentation of the Palestinian nation and all of the Palestinian issues. This was done by design by the Israelis of fragmenting us into different groups, but to ultimately also have our own leadership try to resolve this issue not as a national issue, but also in that fragmented way, was deeply problematic, and certainly a lesson to learn to avoid from whatever is being currently negotiated or explored as policy in terms of policies.
I mean, let me ask you one final question before we wrap up.
Sure.
After all this analysis and a life of caring about, obviously, about this issue, what does justice look like for Palestinian refugees, given using this rules-based approach, right? With establishing, using the established norms of international law as they're stated, what do you think justice would look like?
So, I mean, justice would be for the Palestinians to have the harm that was done to them reversed. And nothing, there's no absolute justice in the world. Nothing is going to bring back our loved ones, the Nakba survivors who are no longer with us, or heal the pain that they've suffered throughout these decades. And so I'm just going to talk about, what would justice look like in terms of enforcement of the law, but not really the concept of absolute justice is just non-existent. But justice for the Palestinians in terms of international law would be for them to be allowed to return to their homes from which they were displaced, to the extent that it is possible for their right to restitution of their property, so to the extent that it is still there, it's still standing. Compensation for the losses that they've incurred since then, because restitution and compensation are not mutually exclusive. They are complementary rights. It's not a choice of either you get restituted or you get compensated. It's the two. And also the most important actually part, I should have started with that, is for the Palestinians to have a choice. The Palestinians need to be able to choose whether to return or to stay or to get compensation or to get restitution. That is ultimately what we're advocating for. Because I also hate how sometimes the right of return is used as a tool not to grant Palestinians any rights because we're protecting your right to return. Well, what if the person doesn't want to return? Because there are some who may not wish to return. They've been, living in Jordan for the 4 generations now. They consider themselves Jordanian. That's perfectly fine. They should have that right to choose, whether to return or not. So the choice, respecting the Palestinians' choice, ensuring that they are able to return to their homes, have their property returned, get compensated for their losses, have a claims commission that addresses their losses and proceeds with the claims, and hopefully it can be a bit more efficient and expeditious, if that's a word, than previous claims. And accountability. I think the most important thing also, even though I don't I tackle accountability from the perspective of reparations and restitution and compensation, but also the acknowledgement of the wrongdoing that was done for the Palestinians. I think this is a very important aspect of the historical injustice that has been visited on the Palestinians and continues to be visited on the Palestinians until today, which is the erasure of the Palestinian identity and the denial of their indigeneity to Palestine. And so justice would be also acknowledging that, so that talking about the Nakba is not controversial. Saying that you're Palestinian is not a political statement, it's just a statement of who you are. And your struggle and your trauma and the injustice that was done against you is as recognized as any other historical injustice in the world.
Amazing. Thanks for trying to explain a very dense topic. I really appreciate you taking the time to be with us. Thanks, Lena.
Thank you, Mike. I appreciate you having me on this podcast. I've always been a fan of afikra, and so it's a privilege to be